So, the purpose of the expert. Why extra testimony is required in ICWA cases. So we talked about that institutional bias, which is really stemming from cultural bias, different worldviews between the dominant culture and tribal culture. So ICWA has improved outcomes for Indian children and families. A lot has changed for the better since it was passed in 1978. However, in big bold letters, Indian children are still removed at a disproportionately higher rate. So the tool to ensure that disproportionality is not based on cultural bias is the testimony of a witness qualified to testify that the removal is appropriate and necessary based on the tribe's child-rearing standard. So we're trying with that expert witness to have this extra layer of evidence that will ensure that when Indian children are removed, it's not for these vague standards that really are just a mask for cultural bias, that it's for some actual either direct harm or potential harm that could come to the child in every case. So now we're going to get into some legal language. And I do want to just remind everyone, so my background is in law. I am a member of a tribe, and I've worked with tribes in Indian Child Welfare Act cases for many years. But as a lawyer, everything, again, my bias is going to be from a bit of a legal standpoint. So I am here to make sure that everyone understands the legal requirements behind the qualified expert witness, and that we all have a lot of clarity around those requirements by the end of the presentation. So with that, we have this fancy citation here to 25 U.S.C. 1912, and that is a section of the Indian Child Welfare Act. And some of you probably have the act committed to memory at this point, so 1912E means a lot to you. If not, this is a good place to start if you're looking for information on the qualified expert witness requirement. So 1912 refers to pending court proceedings, and Section E is about foster care placements, evidence, determination of damage to child. So in passing the act, Congress required that no foster care placement may be ordered in such proceeding, which is a proceeding involving an Indian child, in the absence of a determination supported by clear and convincing evidence, including the testimony of a qualified expert witness, that the continued custody of the child by the parent or Indian custodian is likely to result in serious emotional or physical damage to the child. So that is from federal law. It's right there. And whatever any state does to pass their own law enhancing the Indian Child Welfare Act, this is going to be the very minimum standard that applies in every single Indian Child Welfare Act proceeding in state court. And here we have the standard for termination of parental rights. And you can see it's a little different. So we have no termination of parental rights may be ordered in such a proceeding in the absence of a determination supported by evidence beyond a reasonable doubt. So that's different from foster care, which is clear and convincing evidence, including, again, the testimony of the qualified expert witness. And we've got the same testimony required here, that if the child continues in the home, they're likely to result in serious emotional or physical damage to the child. So I wanted to take a minute now and talk about something that I saw when I was working as an attorney actually for the state of California at the Judicial Council's Administrative Office of the Courts, Center for Families, Children in the Courts. I often got to go and see case files and do audits of ICWA cases to see if judges were making the appropriate findings. And sometimes I would see that a qualified expert witness had testified and that those minimum standards were being met. And other times I would see something in the court findings or in the reports from social services that said ICWA expert. So I wanted to talk about the difference between ICWA expert and qualified expert witness in an ICWA case. Sometimes courts just use the term ICWA expert to refer to their qualified expert witness. But sometimes what I noticed was that courts were actually having someone come in and talk about whether or not ICWA had been filed in the case. And you can use a qualified expert witness to do that. That's okay. However, it's critical that that qualified expert witness testimony that specifically states that the child is in danger of experiencing physical or emotional harm if they remain in the home, that has to be in the record. And so I just wanted to take a minute and talk about the difference. Having someone come in and testify that ICWA either has or has not been followed in terms of placement preferences, active efforts, case planning is valuable, but it's not a substitute for that qualified expert witness coming in, being qualified on the stand as an expert in the child-rearing practices of the tribe, and then stating very clearly that the child is in danger if they stay in the home. So that's just my kind of practice note. And I think the term ICWA expert can be very confusing because what qualifies as an ICWA expert could be someone like an attorney who has an expertise in law, but maybe knows absolutely nothing about a tribe's child-rearing standards. So just something to think about as you go forward and using terminology. Of course, in the law, things are precise and cases can be overturned on appeal due to very technical misstatements. Okay, so I did want to talk about Indian children in care in California today. Again, we're back to California. And this really comes from a lot of years providing trainings to judges. I'm sorry, judges don't get trained. They are educated, not trained. So providing education to judges in California, and then also providing trainings to social service providers and tribal members. And sometimes questions come up as to, why do we need ICWA? Why do we still need it? It's been in place since the 70s. Racism isn't what it was. Myself as a social worker, I'm not racist anymore. Why do we need to have the Indian Child Welfare Act in place? And so this is some data that I think helps explain why we still have ICWA today and why we still need to be diligent about the minimum requirements of the Indian Child Welfare Act being followed in every single case involving an Indian child. Native American children are the second most overrepresented population in the child welfare system. And overrepresented is a term that refers to Native American, in this case, Native American children are represented at a much higher percentage and higher rate in the child welfare system than they are in the overall population. And we'll talk more about disparities in just a moment. But I wanted to make sure everyone understood that term because the overrepresentation of Native American children in the child welfare system is an ongoing problem. And as someone who's been looking at statistics for the last 10 years, there hasn't been enough positive change in that area, in my opinion, since I first started really looking at the statistics 10 years ago. And the majority of the out-of-home placements that are recorded for Native American children in the child welfare system are still not in compliance with the Indian Child Welfare Act, meaning that the majority of the out-of-home placements that are being recorded are still with non-relative, non-Indian caregivers. So here is a chart that I made, and this may be a little different from what you have in your handouts. I think you have a handout. And this shows California in blue, San Diego in the reddish color. And I chose San Diego because I know that we're broadcasting this in San Diego County, and I wanted to just have at least one county to compare to. So if you look on the average in California, the total percent of children in care for just the cross section of compared to the entire population is 0.58%. And in San Diego County, it's lower. It's 0.42%. So that's great. We want fewer children in care overall, especially if that's meaning that fewer families are in crisis and in need of social services intervention. But then when you look at, and these labels are the labels that are used in CWS, CMS, when that report goes to Berkeley to be compiled into statistics. So these are not my labels, but to keep it consistent with how the data is reported, I'm using the same labels as they come out in like I said, in that data. So for Black children, we've got in California overall, it's 2.34%. So compare that with 0.58. That is an example of overrepresentation. That means that Black children are represented at a much higher rate than the overall population is. You can see in San Diego County, they're actually doing a bit better with that number, and Black children are only represented at a rate of 1.91%, but that is still an overrepresentation compared to 0.42. Moving on to Native American children, they are represented at a rate of 2.3% in California overall. And again, that's overrepresented. That's an overrepresentative number compared to the 0.58. And in San Diego, which is a little different than overall California, we've got 2.14%. And you can see that in California, Black children are actually overrepresented at a higher rate than Native American children, but in San Diego, that's flipped. So we have Native American children overrepresented at a higher rate than Black children. And I just point this out because whatever county you work in, live in, practice in, you can look at these statistics online and you can see how your county is doing. You can see how many children are being recorded as being in care. You can see what the disparity is between the different ethnicities. And you can compare that with the general population in California and the county that you're in or that you're just interested in seeing. And you can see the numbers go down from there. So these two populations, Black and Native American, are the only two that are recorded at a overrepresented rate. And I think that there's a connection there between some of the history of California government policies and Native American people and California government policies toward African American people, and also the overall federal policies that affected both of those populations. So while culturally every culture is different, there is some similarity here that we see between these two populations being the only two that are overrepresented in California. And sorry, this number didn't come out, but basically it's 0.00009 for California for the Asian population in care. It was so low, my program didn't even want to display it. Qualified expert witness testimony defined. Any questions up to this point about overrepresentation?
I just wanted to know the website where you pulled your research numbers from. The disparity, ethnicity disparity for the counties. Is that a website that we all can access?
It is. It's a public website, and it's through the University of California at Berkeley. And they've contracted with the California Department of Social Services to take all of the data that gets entered into the child welfare system in California and then process it into somewhat readable form if you like data. I don't have the link right in front of me, but at the break, I can put that up on the screen and everyone can have it. It is easily accessible by anyone. And if you're like me and you like data, you can get lost there for hours looking at different statistics, different numbers, just relating to Native American population. And then if you want to go further, you can look at all the different populations represented in the child welfare system in California and really just get nerdy with it. But I will present that link to everyone later, and you probably noticed those statistics were from July 2013. So the data is never really up to date current. The disparity indices are lagged by about 6 months, and some of the placement preference data lags by 3 to 6 months. So just letting you know that the data still is very good and very useful. And if you start looking at it over time, you can start to see trends. So these are some sources, and I'm not sure these are printed in your handout, but all of this information will be provided either online or at the break so that everyone can have them. The Indian Child Welfare Act, this site here is specific to expert witness. In fact, all of these citations are specific to the expert witness requirements and where you might find these. But these sources are sort of the main sources that will be useful to you if you are interested in learning more about the Indian Child Welfare Act and how that is applied and practiced here in California. So ICWA, Indian Child Welfare Act first, federal law, that's the one Congress passed in response to the wholesale removal of Indian children that was taking place. And at E and F, we specifically have, sections E and F, the qualified expert witness requirements. There's also federal guidelines, and these guidelines are produced by the Bureau of Indian Affairs. They were passed in 1979. They're actually being considered for an update currently. So for anyone who's interested in tracking that, I think that these guidelines have definitely influenced the way the Indian Child Welfare Act is practiced and applied at a state level. So modifications to these guidelines could have a big impact on the practice of Indian child welfare in California and also nationwide. And the guidelines, you should know, are just that. They're guidelines. They don't have the same force and authority as the actual act itself, but they do provide guidance when someone has a question about what a specific requirement means in the Indian Child Welfare Act. And they're not always followed as strictly as, say, an actual code or statute would be, but they have influenced the law specifically in California. As we jump to CalICWA, this was CalICWA came out of a bill many years ago at this point. I think it was, 6 or so years ago. And it was known as SB 678, but we're referring to it now as CalICWA because there have been many SB 678 since then that have nothing to do with the Indian Child Welfare Act. So we want to let that terminology go. And when you're talking about CalICWA, the state of California decided, as is allowed by the Indian Child Welfare Act, to implement the Indian Child Welfare Act into California codes. And they did that through the Welfare and Institutions Code, which you can see here abbreviated as WIC, and that's Welfare and Institutions Code. A lot of people refer to it as WIC. It was also implemented into the Probate Code because that is where we find our guardianship proceedings. It's through the Probate Code and probate courts in California. And it was also implemented into the Family Code because sometimes in family law cases, judges will find it necessary to make out-of-home placements. So a custody dispute can turn into a placement with neither one of the parents. And in those cases, if it involves an Indian child, then the Indian Child Welfare Act would be implicated. So CalICWA isn't one nice, neat statute you can look to. Rather, it's the implementation of those minimum federal guidelines into 3 different codes in California, which has actually been really beneficial because it's hopefully it was meant to ingrain the practice of the Indian Child Welfare Act into all child welfare practice, rather than having it be this other thing that social services looked at, you know, only when someone kind of pointed them in that direction. So much harder to miss the requirements of the Indian Child Welfare Act now in California practice. CalICWA also further expanded on some of the federal laws. One thing in particular was to allow for the participation of unrecognized tribes in Indian Child Welfare Act proceedings. It's at the discretion of the court, but it was California's way of recognizing that not all tribes in California have federal recognition. So the Welfare Institution Code 224.6 and 361.7 specifically talk about the qualified expert witness requirements and provide some guidance there. And some of what's in those codes actually reflects the federal guidelines in addition to the Indian Child Welfare Act. So California has more or less adopted what's in those federal guidelines as being law. And then the California Rules of Court. Again, California Rules of Court do not carry the same weight and authority as a code or a federal law. However, they are instructional to judges in California and to the practice of law in California. And a lot of courts treat them with the same force and effect of a code or a law. There are those judges who don't feel that they have to follow every single rule. So it is going to depend a bit on the court. But it's important that you know that Rule 5.484 and 5.485 both specifically talk about qualified expert witness testimony in Indian Child Welfare Act cases. And if you need to, you can cite to any one of these sources in your argument in court, if, like I said, if needed. I'm getting a question. Let's see. So,
because we do have some folks from Arizona, I wanted to make sure that they understood where they might be able to find similar statutes, or that the implementation of the federal ICWA statute, how it's implemented on a state level. And that might help those from California understand why there's a California statute and a federal statute.
Yes. Okay. So in the Indian Child Welfare Act, the federal statute, there is a provision that allows for any state to adopt more protective standards through state law. So the minimum federal standards apply in every single state, in every single proceeding involving an Indian child. However, if a state so chooses, they can adopt more protective standards. So no one can reduce the standards to be less than what they are at the federal level, but a state can enhance those protections to be more than they are at the federal level. And so California did that through CalICWA, and other states have done that as well. I'm not sure what Arizona's laws are specifically, but it would be something that you would look to the state law to see if there's been more protective standards passed, or if the state law has, at a minimum, just implemented the federal standards. There are still states that they haven't passed any state law on ICWA either way, and so in those cases, it's just the federal law and the federal guidelines that would apply. So that would be the difference, and it really is going to vary on a state-by-state basis. Something that I think is interesting is that while the Indian Child Welfare Act hasn't changed since 1978, and the federal guidelines haven't been looked at since 1979 for any kind of revision or update, CalICWA passed in, I think it was 2009, which is much more recent. And the California rules of court are updated even more frequently. So states, while it's more difficult, arguably, to affect change at a congressional level, at a statewide level, tribes and tribal advocates and child welfare advocates can have an influence through state laws and through state rules of court. So that's something to think about when, going forward. If there's a practice that needs clarification, a lot of times the best approach is to try to do it at a statewide level, just because it's going to be more efficient. And there are also things that different circumstances in each state that are really specific to the tribes in those states and to the Native American population in that state. So I hope that answers that question. All right. Any other questions? So when is a qualified expert witness needed? There are 3 instances when a qualified expert witness is required in every case involving an Indian child. And so it's in foster care placement, termination of parental rights, and then also in a narrow application to deviate from placement preferences. And that's the placement preferences in the Indian Child Welfare Act. So for foster care placement, we've got the burden of proof, which is clear and convincing evidence and testimony of a qualified expert witness. So in foster care placement not involving a Native American child or an Indian child, you're not going to see this testimony of a qualified expert witness being required. That is only required in foster care placements involving an Indian child. So this is an example of that minimum federal standard that's a heightened burden, higher than other child welfare proceedings, designed to ensure that Indian children aren't being placed in foster care for institutional cultural bias. And in termination of parental rights, the burden of proof is even more strong. We've got evidence beyond a reasonable doubt. And beyond a reasonable doubt is a higher standard than clear and convincing evidence. It means that a reasonable person presented with the same evidence would have no doubt that this is the right thing to do. So that's a much higher standard. And the reason is because terminating parental rights is very serious. It's a permanent action that will end all rights of the parents in as to this child. And that includes visitation rights, rights to determine education, obviously physical custody would end. So because this is such a serious proceeding to terminate parental rights, we have this heightened burden that evidence beyond a reasonable doubt is required. And again, we have qualified expert witness testimony being required. And that is not required for the termination of parental rights in cases involving non-Indian children. So some more evidentiary requirements. Something is happening. No, I don't need that. So evidentiary requirements, we've got cultural evidence. So the courts in state courts must also consider evidence of the prevailing social and cultural standards of the Indian child's tribe, including family organization and child rearing. And that's something that we have here in California, sort of a further explanation of what must be required. So when considering whether or not the evidence meets the level of clear and convincing evidence or beyond a reasonable doubt, you have to consider, the court needs to consider that in the context of the prevailing social and cultural standards of the Indian child's tribe. So it's basically, given all this evidence that's happened, considering this child's cultural standards because of the tribe that they belong to, is the placement or the termination of parental rights justified in this case? And this evidence of the cultural standards of the child's tribe is often provided by a qualified expert witness. It can be provided by a member of the tribe or someone else who is then qualified as an expert witness. And specifically, we're looking at the cultural traditions and practices around family organizations and child rearing. So, getting down to exactly what testimony is required, before the court orders foster care, guardianship, or termination of parental rights in a case involving an Indian child, a qualified expert witness must testify, and this is the exact language, that continued custody by the parent or Indian custodian is likely to result in serious emotional or physical damage. And again, this needs to be based on the tribe's social and cultural standards. That paragraph, that sentence, I guess, the continued custody by the parent or Indian custodian is likely to result in serious emotional or physical damage. That is the magic testimony that is needed before the court can make a finding that foster care, guardianship, or termination of parental rights is appropriate in the case. The Bureau of Indian Affairs guidelines and the California Rules of Court state that to deviate from the preferred placement, and that's again the ICWA placement preferences that I touched on earlier, which basically say that Indian children should be placed in their community rather than outside of their community for foster care placements and adoptions, that the court must find that there's good cause to do so. So the court can't just place in non-relative, non-Indian homes without making a finding that there was good cause to place outside of the ICWA placement preferences. And good cause is not perfectly defined, but it is, we do have some guidance from the guidelines and the rules of court. It can include requests of the parent or the Indian custodian to deviate from the placement preferences, requests of the Indian child to deviate from the placement preferences. That often comes through the child's representation, whether it's a guardian ad litem or minor's attorney. And also the unavailability of suitable families based on a diligent effort to identify families meeting the preference criteria. And that should be supported by evidence that the social services agency did make diligent efforts to identify families. So, and that's a very frequent occurrence that you see as the good cause is that one, unavailability of suitable families. And then finally, good cause to deviate can include extraordinary physical or emotional needs of the child as established by a qualified expert witness. So again, we see another place where qualified expert witnesses are needed in order to deviate from the preferred placement preferences in ICWA. Okay, we have to have, if we're going to use emotional needs of the child, physical or emotional needs of the child, we have to have that qualified expert witness testimony to support that finding. So that's something that I'm not sure is happening in every case where the court is finding that the reason to deviate from the placement preferences is the extraordinary physical or emotional needs. I'm concerned that when that is the justification for the good cause, that the qualified expert witness is not being used where they actually should be.
Are there any questions? Hold on, Christine. Are there any questions on the last bit of like the testimony for good cause to deviate? Okay, hold on.
Hi, I have a couple questions, and I'm brand new at this. But my first question is was Was there an expert witness in place from the beginning of ICWA, or was that implemented at a later date? So was that from the beginning in 1978?
Yes, the expert witness testimony has been required since 1978, and in fact, nothing in the Act has changed since it was initially passed in 1978.
Okay, and then at the point of deviation from the preferred placement, should the expert witness have, how much involvement should the expert witness have had in the case?
I'm sorry, Stephanie, can you repeat the last question?
Yeah, at the point of deviation from preferred placement, how involved should the expert witness have already been?
Lost sound.
Hold on.
All right, let me know if this is consistent with what you're asked. At the point of deviating from the placement preference, how involved does the qualified expert witness need to be?
Okay, so when we're using a qualified expert witness to establish extraordinary physical or emotional needs of the child, then that expert witness is going to need to be qualified to testify on the stand the same way the expert witness would in any other proceeding. So whoever is using that expert witness to support their good cause finding that extraordinary physical or emotional needs of the child is going to justify deviating from the placement, whoever is using that qualified expert witness is going to need to show that the qualified expert witness has the information to form an opinion that there are extraordinary physical and emotional needs. And so that could be someone who is experienced in tribal child rearing for this child's tribe, but has some experience with, physical and emotional development of children. And in these cases, it could also be someone who is an expert in, say, child psychology, or even in the area of child abuse. And we'll talk more about what qualifies someone to be an expert as we go on. So I hope that answered your question.